Hi, I'm Hennepin County Attorney Mary Moriarty. Our office has received inquiries from the public asking for information about what it would look like to charge a federal agent in Minnesota. The answer is complex, so to ensure that our community has accurate information, we've created this short video to provide an overview.
Just like with any other person charged with a crime in state court, a case charging a federal agent with a crime would be filed in district court in the county where the crime is alleged to have occurred. In Hennepin County, this would be in Hennepin County District Court. Any federal officer charged would then be able to try to move the case to federal court. In the legal system, we call this seeking removal to federal court. The law requires that if a federal agent who is a defendant in a state criminal case wants to try to move the case to federal court, they have to file what's called a notice of removal within 30 days of their first appearance in state court. If the defendant does file a notice of removal to try to move the case to federal court, the state court proceeding would likely be stayed or put on hold while the issue of removal is litigated in federal court.
Step 2, removal to federal court. A hearing on the defendant's notice of removal would happen in federal district court in Minnesota and would be heard by a federal judge. The defendant would have to establish federal jurisdiction by a preponderance of the evidence. In other words, the federal agent would have to show that their claim is more likely true than not or greater than 50% probability. This is the lowest standard of proof in the law. To establish federal jurisdiction, the defendant would have to meet a 3-part legal test. First, they would have to establish that they're a federal agent. Second, they would have to show that the charged conduct has a connection or association with official federal duties. And third, they would have to assert a colorable federal defense. Ultimately, the federal judge would decide if the case would be removed from state to federal court or remain in state court.
Part 3, what happens next? If the federal judge decides that the case will be moved to federal court, the legal proceeding would continue in the federal court in Minnesota. But the federal judge would be applying Minnesota law, and the case would still be prosecuted by prosecutors from the county attorney's office. If the judge decides to keep the case in federal court, the defendant may try to file a motion to dismiss. They would argue that the federal agent is immune from prosecution under what is called Supremacy Clause immunity. It is important to remember that there is no absolute immunity for federal agents. Instead, the judge would decide whether the case should be dismissed by applying a 2-part test. First, was the federal agent performing an act which they were authorized to do by the law of the United States? And second, in performing that authorized act, did the federal agent do no more than what was necessary and proper for them to do? If the court denies the motion to dismiss, the case would continue on towards trial. And if the federal agent is convicted in federal court, there would be no pardon by the president because the conviction would be under state law. Going all the way back to what happens after the removal hearing, if the judge decides that the case should not be removed to federal court, the case would be remanded or sent back to the state court. And then the court process would continue in state court, including any motions and trial.
We hope this helps answer the many questions we've received about what happens if a federal agent is charged in state court. We are committed to being as transparent as possible about our work. Please continue to reach out to our office with questions and submit additional evidence you may have on unlawful conduct by federal agents to our TAP portal. The link is available in the comments and at hennepinattorney.org. Thank you.